gonna cross and, yeah, direct across.
Okay.
Where do you wanna do this? How do you wanna do this?
Well,
Why don't you sit right at the end of the table there, and then what you guys could do is, because that'll sort of be like the witness box.
Do a depot setting? Why not?
Yeah, then Pete move down a space.
yeah.
Can I, have,
Yeah, that's fine.
the book with me, because it's not exactly my case.
But remember, what we want to see is if you don't remember, you don't look it up. If you don't remember, you tell these yahoos, I don't remember, and let's see what they know how to do. You know, and instead of you just refreshing your own recollection.
Sure.
Hey, does this refresh your memories?
That.
$100 for what?
Oh. Does this refresh your memories?
Well, Ben Franklin
Now, we laugh about that. I had,
we passed money on the stand.
no, I had a case set for preliminary hearing. I had a witness outside, and we took a break, and my cop was out. My cop was dressed in street clothes. And the dad of the defendant walked by and said, hey, you know what? You don't remember anything? I'm going to take care of you.
Oh!
And the cop heard.
Oh, God.
And great, my witness took the stand, didn't remember. And I didn't find out till after that my cop said, I heard him tell him that. It's good stuff.
So then doesn't it become all deemed admitted? Isn't that what we learned last week, since they're feigning?
Yeah, well, yeah, you gotta take some steps. That my witness ultimately admitted that, well, yeah, he told me that, and I was scared, he wasn't doing it for any money.
Yeah.
He was doing it because he was scared. And then he told the whole story.
No.
Guys, move back this way, don't be bearing down on him.
Why not?
Yeah.
Well, I need my attorney right now.
My attorney.
I'm sorry, he's your attorney. If he's your attorney, it's okay if you go a little closer. Sorry about that. I was thinking, geez, normally people are like, oh.
Let me just set the seats over here.
No, but this way we can watch it, that's perfect.
Okay.
So, Your Honor, I'd like to call Jeffrey Kent to the stand.
Okay. Now, are you remaining seated, or what are you doing here? He gets to say he's a witness. You're the attorney.
I wasn't sure.
I was going to stay seated, so everything you have heard.
This is my deposition, so if you need to refresh my recollection.
And Mr. Kent, state your full name for the record.
Jeffrey Kent, Jeffereykent.
And Jeffrey, let's learn a little bit about yourself. Before the incident, what did you used to do for a living?
I was a fireman.
Fireman, huh? So did you have any experience with construction work or something like that?
I don't believe so.
You
No.
think so? Did you ever want to be a construction worker? Or you
No,
didn't?
I never did any construction.
So you had no experience with construction work?
No.
No? All right. And let's see. And on this day, well, you went into the defendant's rental shop, right?
Correct. I went to the Bonds rental shop, right?
Yes, you went. Well, can I answer? And what were you doing at Bonds rental shop that day?
My mother wanted me to help remove her driveway, so I needed something to break up the rock.
Okay, what were you going to use to break up the rock?
I went there to try to find a jackhammer.
Okay. Have you ever used a jackhammer before?
No.
Right. Yeah. So when you went to this jackhammer, was it your first time? Then were you instructed on how to use a jackhammer?
No, I don't recall. I definitely signed some paperwork.
Signed some paperwork. Did anyone give you a lesson on how to use a jackhammer?
No.
No. And did it tell you about what kind of safety equipment to wear?
Not that I recall.
Okay. And the paperwork, did someone go through with you and tell you about the dangers that could happen with this jackhammer in particular?
Somebody might have told me something, but
Okay.
yeah, that was the definition. Sorry.
Okay. So let's see. So now you have the jackhammer. You're back at your mother's driveway.
Correct.
Okay. And so how did you prepare to start working?
Right. So it was a hot day. I just kind of got started. I think I was, just after get started.
Okay. So you're working. Let's see. So do you recall exactly what happened when you were digging away at the driveway?
Sure. So I was jackhammering the rock out of the driveway, and it just hit like a hard spot or something. I don't know, and it jumped on me and landed right on my foot.
Your foot. Okay. So what happened to your foot?
I lost 3 toes.
3 toes. Which toes?
My big toe and the next 2 toes.
It'd be kind of hard to be a firefighter like that.
Yeah, I had
Objection, argumentative. I need a judge.
Overruled.
How's overruled?
He wasn't arguing with him. You might have another objection, but it wasn't argumentative.
Bleeding.
Overruled on those
Not
grounds.
leading either.
Carry
It
on.
must be hard.
Right, so I have not been able to work since, and yeah, it was really my, I was a fireman. It was my calling, and my,
So what have you been doing since?
I've been unemployed since and disabled.
So.
Getting hooked on opioids.
Yes,
Sorry.
really quick. Yeah, how long did you want to be a fireman?
Well, I wanted to be fireman my whole life. It was like my childhood dream, and I worked so hard to get there, and I made it, and it was something that I was very proud of, to serve my community, and literally I rescued people, I saved people's lives, and it was fulfilling.
No further questions?
Okay.
That's not my done on the arguments.
Sorry, I have to ask, what is an argumentative objection? Like, I thought if they said,
Hey, Mr. Smarty Pants. It's just being nasty to the witness. He was
I thought that's badgering.
That's what argumentative is. There is no such thing as badgering. That's only on TV.
Oh.
But hey, tough life must have been tough for you. That's not argumentative. He's not trying to embarrass him or belittle him. He's giving him, he's basically showing him some sympathy.
So speculation or leading, or what would you go for?
Well, you could say,
There's no question.
yeah,
Well, I mean, it is a question, but it's more of a statement than a question. But
yeah. You could say it's leading because it's he's supposed to be on direct examination. He's supposed to be asking, what if anything happened next? When you went there, what did you do? So, but you let him get away with all that all the way through. So it's okay.
I'm not used to raising objections as they're talking, which I know is the key point. But
I write objections. Yeah, I've never seen anybody actually give an objection in court.
Really?
Yeah, it doesn't happen. So
You gotta come and watch.
well, I've seen it in criminal law. Yeah, a lot of times, but it doesn't.
Not in civil.
No, we write them.
Proceed, sir.
good afternoon, Mr. Kent. How are you today?
I'm good, thank you.
So there's a couple things that I want to go over with you that your attorney just went over with you, if that's okay.
That's okay.
So the first thing that I wanted to mention or to ask you was, you had said that you had never had experience with a jackhammer before, correct?
I believe that's correct, yes.
Well, I'd like to point you to your deposition testimony. It's on page 41, and I have part of it highlighted for you, but if you could read your answer, the question before on page 40, and then your answer on page 41, please.
So question, have you ever used a jackhammer before? Answer, I have a buddy who rented a jackhammer once. He let me try it for a few minutes. It didn't look hard to use. In fact, it was kind of fun to use. Boy, was I wrong.
So, in fact, you have used a jackhammer before.
For a couple minutes, yes.
Okay, I just wanted to clear that up, make sure that I remember that correctly. So, you went to Mr. Bond's rental store, correct?
Yes.
And when you went in there, did you ask for any specific kind of jackhammer or anything like that?
I don't think so. I think I just went in and asked for a jackhammer.
And did you ask any questions about this jackhammer when you were getting it?
I don't think so.
Did you ask about its power?
I don't recall.
Did you ask if it
I
had...
had to move an entire driveway full of rock. Yeah, I needed a good jackhammer.
Did you ask that?
I don't recall. Yeah.
And then when you were doing that, were you asked if you had ever used a jackhammer before?
I'm not sure. Or no, I'll say no because let's see you. I don't know. No, I don't.
How are we supposed to do this? Because I can't get Mr. Bonds' testimony in.
Yeah, you can't. Oh, Mr. Bonds.
Yeah.
Oh.
No, but you just gotta treat him.
So
like
just treat him like
you're gonna get
like
it.
I'm gonna get it in.
Right.
Okay. Because that's kind of the problem that I was
But you
having.
gotta lock him in.
Vincent, what do you want to say?
Well, I want to get in that.
Isn't it true that you were told how to use the jackhammer? Isn't it true that you were shown?
Well, I'm not there yet.
Yeah, well, you
I'm
haven't
good,
had
yeah.
you haven't had any leading questions yet.
Well, no.
This is cross-examination. Leading question.
It doesn't have to be leading. Let me do it how I want.
Only if you want to do it right. Only if you want to win and get your point out. So go ahead. If you know what a leading question is. I just want to make sure.
Do I get to make smart aleck remarks too?
I think you can say something like, well, do you know that the person you spoke to just said, like, pretend they went first or something. I don't know.
No, but you don't have to do it that way. Just you know what I'm saying. You know, isn't it true that Mr. Bonds told you this?
Well,
Yes or no?
I was going to get there, but I mean, as far as getting in his testimony, I mean,
No.
there's no foundation, there's no nothing, and I mean, I'm cross-examining in a vacuum.
And that's why. But you would cross-examine him the same way,
Okay.
right? Even if you had Bonds in your back pocket and you know you're going to call him, you're still going to question him the same way as you would right now.
Okay.
Right? You're just not going to call Bonds to impeach him.
Victor, what you want to, you're telling your story. All the words that come out of your mouth are telling your story, and all he's going to say is yes or no. That's all you want him to do. You don't want him to say another word. Okay, so if you know what your story is, I want to say this. I want to say he went to the store, he didn't pay attention, he was checking out the blonde girl, Mr. Bonds told him everything he needed to know, he didn't wear the right shoes. Yeah, just tell your story. Isn't that true, sir? And all you do is tell the story, get him to endorse it. That's all you need to do in cross-examination.
Oh. That's easy enough. So, Mr. Kent, I want to point you to the rental agreement that you had signed at Bond's Rental. If I can find it in here. Take a look at that. Tell me if that's your signature, and those are your initials next to it.
Yes.
Are those your initials where it tells you that it should not be used while under the influence of alcohol?
Yes.
Are those your initials next to it where it says proper safety attire must be worn?
Yes.
And next to your initials, does it also tell you that if you do not know what proper safety is, to look at the safety manual?
Yes, consult safety manual.
Isn't it true that you were given the safety manual as my client was filling that out for you?
Yes, I was.
And so let me point you to the safety manual here. Isn't it true that the safety manual lists what safety equipment you should be wearing?
It does.
And what are those safety equipment that you should be wearing?
Hard hat, safety goggles, and steel-toed shoes.
Thank you, Mr. Kent. So let's go to when you got to your mother's house. You said you just kind of started, right? Did you do anything before you started? Did you have lunch?
Yeah, I think I had a beer, actually.
Okay. And so you violated the safety information that you assigned, correct?
No,
No.
correct. It says intoxicated.
Actually, I believe Mr. Cadden says under the influence of medication or alcohol. So you did have a drink, correct?
No.
At
Yes.
lunch?
Yes.
And then you also had a second drink as you were outside jackhammering the driveway, correct?
I think I only had one beer.
So you ate your lunch without anything to drink?
You know what? I don't recall. Yeah.
Okay. So let's go into what you wore when you were jackhammering, as you just listed the safety equipment that was required. Do you remember what you were wearing on the day that you were jackhammering for your mother?
I think I was wearing sandals. Is that right?
No.
Oh, sorry. Was it? I was wearing.
Let me refresh your recollection, sir,
Okay.
with your deposition testimony. If I can find it again. I can't find it. Do you know where it is, Victor?
All I read was the deposition.
Well, it's in the deposition. I just don't remember where it is in the deposition. Oh, here you go. So I'm going to direct you to page 44. That answer right there, sir. Can you read it for me?
I put on an old shirt, jeans, some safety goggles, and sturdy running shoes.
So you did wear safety goggles,
Yes.
but you did not wear the steel-toed boots that were listed in the safety manual.
Correct.
And had the jackhammer jumped before this had happened?
Yes.
And did you change your shoes after it had jumped?
No.
And did it only jump once before this had happened?
No, when it would hit a hard spot, it would jump.
So it jumped a couple times before this would happen?
Yes.
And you still didn't change your shoes?
Correct.
I have no further questions for you.
Can I do a redirect?
You got anything?
Redirect.
You have really sturdy running shoes.
So you had one beer. Would you say you were you under the influence of alcohol, or was it just one beer?
It was just a beer.
About how long was it from when you had the beer to when you actually sat down to or started jackhammer?
I don't recall. I just had a beer.
All right. Do you recall the time you got home that day to start working on your mom's driveway?
No.
You know where it is, right? It's like 45 minutes.
Oh, between when you had lunch?
Yeah.
Yeah, it's right there. 42.
Right, so I had lunch, and about 45 minutes later, I got started.
So would you say you were still under the influence of that beer you initially had at lunch?
I would say I never was under the influence.
Never were under the
Yeah,
influence.
it just had beer.
Okay, so you're fully able to operate the jackhammer without any
Yeah,
influences.
I was not intoxicated.
And on the previous occasion where you used the jackhammer, did it ever jump at you or anything?
No.
No, you only used it for a couple minutes, right?
Yeah, it was actually fun.
Right, and it seemed relatively easy to use. You did not expect the jackhammer to jump. Right?
Gee, what kind of question was that, Vincent?
Prevented.
It was leading question.
Leading, I don't.
He's doing direct and you're letting him get away with leading questions?
You got a comment so I could learn how to rephrase it because
Sorry.
I'm not aware I do it.
Objection leading.
Sustained.
Um,
Answer will be stricken.
That's what will be stricken. Had the first jackhammer you ever used jump?
No.
And was this your first time experiencing a jackhammer jumping with the one from Brock's Industry?
Yes.
Okay. And
I would jump into my injuries.
your injuries?
Well, it's a bifurcated trial, so that doesn't matter.
But it's just a sad story.
It doesn't matter.
Then were you able to get your any workers' compensation from losing your toes?
Objection beyond the scope, it's beyond the scope of cross.
It is.
It is?
Sustained.
But you still have to prove damages and negligence.
Yeah, but he didn't bring it up during direct, so he can't bring it up during redirect.
Ah,
Fine.
okay.
Okay.
Someone that,
You're fine, Victor. You
afterwards
don't,
I'm
you don't have to ask any questions, only if you have some.
okay. But no, afterwards, like, better be indirect. Like, I can only rebut what he said. Right?
That's what's supposed to happen.
Okay.
You're supposed to, on redirect, go back to anything that he brought up and either explain it, expand it, do whatever you need to do, but not bring up new stuff.
Oh, gotcha. Okay. All right. I can't be honest. So when they gave you the manual, did anyone tell you to read the manual, or did they sign up?
I don't think so. I just signed a piece of paper and I had a jackhammer and there was a manual there.
Okay. And Mr. Bonds made no effort to get your attention and really get you to, I guess, some check how to use the check.
Somebody might have said something, right? Isn't that my answer? Yeah. He might have said something. I don't remember.
Okay. No further questions.
Good.
Can I reread it?
You can recross.
Or recross?
You gonna keep recrossing?
You said it had been 45 minutes since you had your drink, correct?
Yes, sir.
At lunch?
Yes, sir.
Did you bring a beer out with you to jackhammer with?
Maybe.
So isn't it true that while you were jackhammering, you were still drinking beer?
Maybe, yeah.
And you also said that Mr. Bonds had never tried to go over the safety manual with you or the agreement with you, correct?
No, I didn't say that. He might have said something. I don't remember.
Isn't it true that you can't remember because somebody had come into the store that you were more interested in than the safety manual that was being gone over with you?
No.
No?
Isn't that at the time of the accident?
No.
Oh, the girls in the okay.
In the rental store.
Oh yeah.
No further questions, Your Honor.
No, no more.
There's no more?
There's
No more? Okay.
enough.
Let me tell you, Victor, were much better on redirect than you were on direct.
Yeah.
You felt more comfortable. You appeared more comfortable. If you can have a conversation with him, have a conversation with him. On direct, though, it looked like you didn't want to use notes, and you stood there and we could all see you thinking.
Yeah, I think
Don't stand there thinking. You would be better off at that point, to look at your notes and ask a question than to stand there like you're trying to come up with something.
I think at the second half, I felt like I was just arguing with him like I usually do.
And you could have used some. You guys talked about paperwork. I signed some paperwork. You talked about it, and then you didn't introduce it. You let the defense introduce it on his terms. I probably would have introduced it. You got away with quite a bit of leading at first, and it really seemed like to me when you ended your initial direct. And granted, we know the story because we've heard this a few times, but it seemed like there was a whole lot missing.
Yeah.
There was a whole lot more to the story that you could have brought out, and that's how you gain that credibility with your witness is allowing him to tell the story, right? That the real exciting part of this story is he lost the toes, right? The jackhammer jumped, you lost 3 toes, you asked him, well, which 3 toes were they? It was the big one and the next 2. Well, it's hard to be a firefighter after that, right? And that was it, right? And you moved right on. It's like, that's your impact right there, and you just slid right past it. So I think you could have done a lot more digging and brought up a lot more facts that would have been beneficial in laying the scene. I didn't get the impression that he is this loving son that wants to take care of his mom and wants to, make sure his mom has this good driveway and it's got to be done before she gets home from, that there was just more that I would like to see you have gone into. Vince, you started out not leading. You got into leading. And I just want to make sure you guys remember how you go about if you want to impeach somebody. You know, what were you wearing? I don't remember. Show him the page. Ask him to read it to himself. Let me know if this refreshes your recollection. Right? If he says, yeah, it does, okay, what were you wearing? You don't ask him to read from it. You ask him if it refreshes his recollection first. If it doesn't, and you want to impeach him with it, you just got to hit him with that statement. Isn't it true you said in your deposition A, B, C, and D? And he'll either say yes, no, or I don't remember. So seeing this right here in black and white doesn't refresh your memory. No, it doesn't. So I would have liked to have seen you lead more after the fact. And you seem to do a good job making points. I thought probably your best area was when you were walking him through the list. Right? Isn't it true? These are your initials right here. That said, no alcohol, and isn't it true? And you went down that list. That was really impactful. And I would have. You kind of could have gotten in and gotten out, but he's done now. And we did a little back and forth, and I don't think the story came out well at all as far as what he had to offer to the case.
Victor, let me tell you something that, at least it helped me when somebody told me. You talk to the witness like you're doing a television interview. So we're here, Mr. Kent, because of your injuries. And so we want to ask you some questions about that. So tell us about your experience in the Bonds rental store. What happened when you went there? Why did you go there, first of all?
I went there to get a jackhammer.
And why did you go to get a jackhammer?
I was going to repair my mother's driveway.
And how did you think you were going to repair your mother's driveway?
So I needed to remove all the concrete and then refill it.
And had you ever done construction work like this before?
Nothing like this.
And so you were going to do this yourself?
Yes.
And so you went in the store, what? To get the necessary equipment?
Correct.
And what happened there?
I went up to them, I told them I needed a jackhammer, and they provided one for me.
Did they give you this pamphlet that told you about the jackhammer?
Yeah, there was a pamphlet that was with the jackhammer.
Did they spend much time going over that with you?
Somebody might have said something, I don't remember.
Do you remember them pointing out any details of what was necessary in order to safely use the jackhammer?
No, I don't think so.
Did they point out anything to you about the kind of clothing that you should be wearing?
No, I don't think so.
The kind of shoes that you should be wearing?
No.
And so they essentially gave you the jackhammer, and then what happened?
And then I took the jackhammer home to my mother's house, and I had lunch there.
All right, and after lunch, you started your work. What happened?
So I was jackhammering, and it would jump a little. It was a powerful jackhammer. It would jump a little bit, and sometimes when I would hit a hard spot, it would jump in this. It jumped and went right into my foot.
So before it hit your foot, did you feel you were able to control it?
Yeah.
And then when it jumped and hit your foot, what happened?
It took off 3 toes.
Which toes did it take off?
My big toe and the next 2 toes.
So you see, Victor, you're just letting him tell the story. Now, I slip in a few leading questions along the way. We always say those are just foundational to get you down the road. But essentially, he's the guy doing all the talking. That's what we want when we're on direct examination, is to get him to do all the talking. The opposite is true for cross-examination. We don't want him saying any words but yes or no. And we want you to tell the story. So let me get, oh, by the way, bringing up in your redirect the beer again is not a good idea. The beer is not a positive for your case. So bringing it up and saying it wasn't very much just reminds me, oh yeah, there's beer here. And if I'm the jury, I'm saying, the guy's drinking beer while he's doing this is wrong. So don't bring that up because it doesn't help your story. So Victor, let me just tell you, this is for everybody. But first of all, this is just my own personal opinion, so you can take it and do what you want with it. I think, hi, good afternoon, how are you today, buddy, is all old news. I think really good lawyers don't do that anymore. I think you just walk up and you start to say, I'm gonna ask you some questions about what happened to you, Mr. Ken, all right? Just like that. I mean, you just start out that way. And then you tell the story that he got him to tell, but you tell him the story the way you want to hear it. So you say, you went to the store, right? And you were given a manual to tell you the safety requirements. And you were told to wear steel-toed shoes, weren't you? And you were told to wear goggles, weren't you? And you were told to wear safety clothes, weren't you? And you acknowledge that you were told. So you get the idea you're telling, and he's just saying, So that's the first thing. When you're on cross-examination, you should own the story.
So why can't I bring up like their past testimony that they had just given to refresh it in the jury's memory? Oh, he just said all this stuff, and then
why would you do that rather than just assert what it was and get him to say yes? And then if he says, I don't remember that. Oh, you don't remember? Let me show you page 41. See if this refreshes your recollection. Just read that to yourself. Okay, does that refresh your recollection? Yes, it does. Well, then what happened? So you see that? Of course you can do it, but it's not some game of trying to drop it on his head because you caught it. And by the way, the quote that you had him read, that didn't help you. Boy, I was wrong was the last thing. Okay, now, so he's just basically saying, I got screwed.
Calm down.
Who, me?
Yes.
Well, I'm just telling you how to do this.
I get that.
Okay.
You could be a little less condescending, though.
Do you think it's condescending to try to teach you how to do cross-examination?
I don't, but the way that you're doing it.
All I really want to do is have you get it. I apologize. I'm just trying to be emphatic. I think the deposition part, if you want to get out the part about how I've never, or I just, saw my friend do it, that's fine. But then I have to say is, you've really never done anything in construction, right? No, I haven't. Well, the one thing you've done is see your friend use a jackhammer, right? You didn't get any training or education on using a jackhammer, did you? Right? One other thing that's really important is there's this theory that you don't want to ask one question too many.
Mm-hmm.
So you say, you know that you're not supposed to use this jackhammer with running shoes versus steel-toed shoes, right? And you violated. Well, that's not for now. That's not for cross-examination. That's for your closing argument. Because sometimes when you do that, you get an answer that you don't want. You give them an opportunity to explain their way out. They were steel-toed running shoes. I'm not stupid. You know what I'm saying?
Yeah.
So instead of saying you violated and trying to get him to say something he doesn't want to admit to, you just say, you weren't wearing the shoes, were you? And then in the end, you said, look, you violated every rule. He signed the initial, I'm going to wear steel-toed shoes, I'm going to wear these pants, I'm going to wear whatever, however it was in the stuff. So the things I want you to remember are, do everything you can to do leading questions. Don't ask one question too many. So when you get to the point where you've got him saying he didn't wear steel-toed shoes, he wore running shoes, and you've already asked him before that you were advised and you initialed that you were going to wear steel-toed shoes, you're done. Or wait till the end, because then they can't come back and answer you violated the rules. Mm-hmm. Because then, of course, he's not fulfilling the requirements or doing what he has to do in order to have liability. And what was the other thing? There was one other thing in here. This is just what happens when you're nervous and everybody does it. So you were asking afterwards, I just wanted to make sure I remembered that correctly. Well, that comment has nothing to do with anything. And it just is a little weird, you know what I mean? Because if you were being emphatic, you would say, what does anybody care whether you remember it right or not? That's not what this trial is about. It's about what happened to him and whether or not he is the guy who caused his own problem or whether or not the jackhammer caused the problem. And they are just nervous things that people do sometimes when they're trying to fill up time.
The reason that I did it, and I'm getting it now, is I had this idea in my head that, like, for cross-examination, and as well as with the reading, but that you try and point out, and I could have done better, the lies that they told during direct, not necessarily from past recollections where I can be like, didn't you say this during your deposition? But reminding the jury, they just said this on direct, so they lied in open court, and now I'm going to point it out explicitly to the jury. This is what you just said. This is what you just said. Well, didn't you say this? Didn't you say that? Is that the wrong way to do it?
Just what you did is perfect, because you just said in a leading question, didn't you say this? Didn't you say that? Not here. Why don't you read this and tell me what you said? You get the difference?
Yeah.
So you're absolutely right. You should do that, but you should do it in the way where you're asking the question and you're forcing him. And then if he says, I don't remember, then you say, well, here, would it help you to take a look at your deposition on page 40? Just read that to yourself and see if that helps you. Oh, yeah, I did say that. So this is a common thing that happens because we think we want to show people their deposition or their prelim transcript or whatever and have them read it to you. And that's not what that's not how the impeachment goes. As Pete said, you have a process you have to follow. You have to, if they say no or I don't remember, then you say, you think it might help to refresh your recollection, take a look at it. If they say yes, then they're going to say what's in there. If they say no, then you say, well, isn't it true that you said on page 41? Because you can do that after you get them to refresh their recollection and they say, I don't remember. So that's the process.
And one of the, I know you were focused on the facts and the story, but one of the areas that I thought you had a lot of room to play with that you didn't was, and he's a fireman, right?
Yeah.
You're a fireman, right? You use big equipment, right? You don't use big equipment without the right safety equipment when you use it.
All in my head too. I just
And
I phased over it once I stood up and got going.
You wouldn't go out on a fire call in running shoes, would you?
And that was my argument. I've not even told them that. I'm like, you wouldn't go to a fire in running shoes.
well, all the more reason
Yeah.
to write your points down, not necessarily the questions, but write your points that you want to get into. So as you're prompted, oh yeah, I want to take him down this track.
Yeah.
You know.
I love that.
So I don't know how you did as a witness, Will. You know, you didn't really remember that much.
He was a good witness because it was a little, not slimy is not the right word, but I mean, I don't know, I don't remember. Get a lot of those.
I'm the plaintiff. How many beers did he have in the
One.
He only had one.
I made one over his stand.
But he said that there was nothing else to drink in his mom's house. So
That's why he drank beer instead of.
yeah, that's why he drank beer.
Now I may have shared this story with you guys previously. I had a case where my guy was uncertain, and the defense attorney said, "Didn't you do this?" And he's like, "I don't think so. I don't remember." And he's like, "Well, if it said this in this report, would that refresh your recollection?" Because, look, if it's in the report, I must have said it, or I must have did it. And so you did this. I guess.
Oh, that's
I guess.
funny.
Yes. And the client and the victim just basically gave in and said, yes. It was all on cross. And my next witness was the guy who wrote the report. Any of that in your report? No.
No.
It was in the report.
The guy just made that up? That's just wrong.
Yeah,
I can't believe people, that's like such the amateur hour, you know?
Yeah. But
Like you're not gonna
the
notice.
witness
Good thing it was already done at that point, right?
Yeah, he was like, I don't know. And he was like, if it's in there,
It's in there.
it's got to be, right? I'm not saying that's not true. I don't know.
Yeah.
So if it's there, it's true. Yes. And he basically agreed to everything. And
Yeah, then they got it shoved into their face. I mean,
Yeah.
that's just like dumb, isn't it? I mean, I'll just make stuff up and the guy keeps saying yes. I mean, people do that. They say, it's like a 3-year-old case. They go, I don't remember, but if it's in there, I must have said that. That happens all the time. But it's because you have something in the report. It's not because you made something
And you're
up.
not misrepresenting the jury.
Yeah,
or
yeah, that's just
it's
bad.
gone, like,
Some will.
That's bad. That's just bad.
So what do you want to do? You want to direct or you want to cross?
okay, so, I don't care. I don't
I
care.
think you should direct so I can be free.
Alright,
Kind of sort of.
alright.
Here, do you want this open to whatever page it's on, or do you have your own highlighted stuff?
Wherever my book is, I don't know. I think it might be next to Victor's.
So we're crossing the drug guy.
Yeah.
Sorry, Vincent, I've been in trial for the last.
No, it's okay.
So I'm
I'm
in
sorry.
trial mode, sorry.
I'm sorry.
No, that is true. You get that way.
I'm gonna use yours then.
Okay. It's 190, page 191.
Because I might have,
Isn't this yours?
I think this was.
Yeah, no, because Victor's is down there.
Oh, okay, then, then.
Mine.
You want to pick or are you okay?
Oh, okay. 191.
So you're Mr. Griffith, right?
Yes.
Good morning, Mr. Griffith. I want to take you back to 6 months before the incident.
Okay.
Where were you working at this time?
I was working at a school.
What did you do?
I was a teacher.
Were you married this time?
Yes, I had been married to my wife. Can't remember her name. Mrs. Griffith.
It's okay. And is there any other teachers at this school?
Yes, of course. There's multiple teachers at the school.
Are you close to any of them?
Unfortunately, I did enter into an affair with Miss Donna Kevins.
Donna Kevins. Now, I want to move this forward a little bit until the spring. Is there anything about Donna Kevins that happened in the spring of last year? Or the year of the incident?
I do know that she was absent from school for about a 2-month period, that I had found out that she was actually had to take mandatory leave from the classroom.
I can get the character evidence in, dude. I'm prepared to actually
No.
give checks. Do you know why she had to take a leave of absence?
I believe my wife had told me that she was on a psychiatric absence.
Okay. Now, so you were in a relationship with Donna Kevins. Do you know when this ended?
It was sometime in either August or September.
Okay. And who ended this relationship?
I did.
How'd you take it?
Not well.
When school started, you guys were both teachers. How did that work out?
You know, she would not, it didn't go very well. I ended up actually getting a lot of notes in my teacher mailbox stating some really threatening type stuff.
What did these notes say?
You know, I'm not exactly sure exactly what they said, and I don't want to misrepresent what they said.
If I can present one of these notes, would it refresh your recollection?
More likely than not.
With your permission, Your Honor?
Yes. Just take a look at it, read it to yourself, and
Take a look at it.
afterwards,
Read
let
it
us
to
know when
yourself.
you're finished reading.
Let us know when you're finished reading.
I'm good.
What do these notes say?
Well, the one that I did keep said, "You'll be sorry," or "You're a terrible person, and I'll make you sorry."
I want to move forward to the day before I want to move to how do I get this done? I want to move to Friday, October 4th of last year. It's the day before the incident.
Okay.
What happened on that day?
You know, I was in the school parking lot, and there was an unfortunate little fender bender with somebody there, and there was some damage done to my car.
What color was your car?
From what I remember, it was a black SUV.
What happened next?
You know, I was in a hurry. I didn't want to deal with my insurance or anything like that, so we had made the agreement that I would pay her $500 and we would call it even.
So you paid her? Oh, did you pay her?
Yes, I did. I paid her right there in the school parking lot.
What'd you do next?
I went home.
So let's move to Saturday. What do you do on Saturdays?
You know, especially since I was having the affair with Miss Evans, my wife didn't know about it, and I had ended it because I really wanted to work on my relationship with my wife. So we had a standing date night going, and every Saturday, basically from the time that I had ended it with Miss Evans, we had a standing date night.
What would you do on these standing date nights?
You know, we would just sit on the couch, we'd have cocktails, we'd eat dinner, we'd watch movies. I mean, what do any other married couple do on date nights?
So what was the purpose of these date nights?
So that we could re-find each other, get closer to each other, work on our marriage.
How's it going?
I thought it was going really well. You'd have to ask my wife how she thought it was going.
So what time were you at home on that day?
I had went to the store. I had gotten some alcohol, some food.
Let's take a step. Let's take a step back and work through this.
Okay.
So you went to the store about what time?
Probably around 2:30, 3.
What did you get at the store?
I got food for our date night and some alcohol.
What did you do after that?
I drove right home.
And about what time did you get home?
I got home probably around 4 o'clock.
So when you got home, what did you do there?
I'm not sure. Can you rephrase the question?
When you got home, what did you do there?
Oh, okay. I'll say it again. When you got home, what did you do there?
I cooked dinner for my wife. We had some cocktails. I probably indulged a little too much.
Let's stop there. So about what time did you start drinking?
Probably as soon as I got home. I mean, 4 o'clock.
Okay. And so you were drinking that whole evening with your wife?
Yes.
Leading. I shouldn't say it anyways.
Actually,
So did you notice anything unusual that evening?
You know, we were sitting on the couch and I noticed somebody was out at the street next to my car. And so I decided to go out there and investigate it.
About what time was this?
I was kind of drunk at that point, so I really can't answer that question. I don't recall.
Okay. Would it surprise you if the police officer said it was 10 o'clock?
That would not surprise me.
Did you go outside?
Yes. At that point, I was in my bathrobe, and I went outside and met who I found out was an officer at my car.
What did he say?
He said that he was investigating a hit-and-run accident that had happened that night.
What time did he that the accident occurred?
I believe he said it was about an hour before he had gotten to my house.
And where were you at that time?
I was on the couch with my wife.
Did you tell the officer that?
I did.
How did you take it?
He seemed skeptical because he was still asking me questions.
So what happened next?
My wife had come out and told him that I had been home. He then asked me to do a field sobriety test and to do the breathalyzer test.
Did anyone arrive at this point?
Yes, Miss Evans showed up at my house.
What'd you say when you got there?
I don't recall her exact words, but she was angry.
How did she arrive?
From what I can recall, I think she screamed into my driveway with her car and was just angry. That's all I can remember is her anger.
Did she do anything to you?
Yeah, she slapped me.
What did the police officer do?
He had to restrain her, actually. I actually believe at some point she had been handcuffed and was put in the back of his car.
After that, what did you and the officer do?
I did the field sobriety test. He asked me to blow into to do the breathalyzer test. I had refused. And so he had asked me to do a field sobriety test, which I begrudgingly accepted to do, even though I had not been driving that night.
So you had not been driving at all?
No, I had been home with my wife.
So did you pass or fail this field sobriety test?
I passed some parts of it, I failed others, but in the totality of the circumstances test, I guess I failed.
So what did you do? What did the police officer do?
I was arrested and brought down to the station.
Did you speak with the police there?
Yes, I did.
What did you say?
The same story that I gave them at the scene, that I had been home with my wife, that I had been drinking at home, and that I hadn't been driving that night.
Did anybody come to get you?
I'm sorry?
Did anybody come to pick you up from the police station?
I believe my wife was there. I believe she followed us after I had been arrested.
Do you happen to know if you spoke with the police?
I do know that she spoke to the police because I had actually sent her home to get the note that I had talked about earlier that was left in my school mailbox.
It doesn't matter.
No, I sent her home.
What's that?
I sent her home to get it.
Okay. Don't argue with the witness. No further questions. Thank you.
That is a hard one considering. Isn't it true that your license is expired?
It is, unfortunately.
Did you know your license was expired when you've been driving?
I did, but I've been busy at work and I just hadn't gotten around to it. You know, between grading papers and trying to make things work with my wife, I just hadn't had time to get down to the DMV. You know, working 9 to 5 at a school when the DMVs are open, only having Saturdays and Sundays off, I just haven't had time.
Okay. And
I should probably object to that.
okay.
You gotta give us grounds, you can't just object.
Relevance?
Relevance, what was the question?
Wasn't my driver's license expired?
Overruled.
So how long would you say you've been dating, you were dating Miss Cadence?
I wouldn't necessarily say dating, but I believe it was around a 6-month period.
6-month period? But how long ago did you guys break up?
I believe I ended it probably about 6 weeks before the accident had happened, or the incident had happened.
See, what time did you say you began drinking?
As soon as I got home, so 4 o'clock in the
4
afternoon.
o'clock, so you've been drinking for 9 hours since work. So 5 hours since 4 o'clock.
Yes, at home.
Okay. Yeah. That's a hard case.
Phone calls.
Phone calls.
You were calling her. You were stalking her, weren't you?
Did you maintain contact with this kid?
I did, unfortunately.
You're supposed to be my witness.
And after were these social calls?
No, I really don't. I don't recall what the substance of these phone calls were. It could have been about school, seeing as we worked together.
Cool. So is it normal for employees to have
Victor.
calls?
Are you asking leading questions?
Oh, should I? Yeah.
Yeah, you
Yes,
should.
it should be.
So,
Same problem I had.
what do you want to say? What do you want the jury to know?
And he's
He's got his expired license. Your license is expired, isn't it, sir?
Yes, it is.
And your license was expired when you had the fender bender in the school parking lot, wasn't it?
Yes, it was.
And you paid the person off in the parking lot rather than reporting that accident? That's what you're telling us?
Between an agreement between her and myself, yes,
Right, and you paid cash,
I did.
so you have no receipt, do you?
No.
So you see what I'm saying, Victor? You want to tell that story? You just tell him what the story is and ask him to say yes. Okay, try and see if you can do a little bit of that.
So you kept contact with these kids?
I did.
And these contacts were not during school hours?
They were not.
You called her at 3 a.m. Several occasions, right?
Good.
I don't recall.
I recall a receipt here from a reliable party.
Objection. Relevance, 402 and 403. This is not his number, according to the police report.
Overruled, and no speaking objections as to grounds. And if you want to refresh somebody's recollection, you can show them something. Don't start reading what there is in the material until you show it to them to see if you can refresh his recollection. You're saying that you didn't call, right?
You're saying that you didn't call, correct?
Correct. No, I said I did call.
Did call.
No, I did call.
You don't remember 3 in the morning? Is that what it was?
He asked me if it was 3 in the morning.
So see, can you see, Victor? You
Yeah.
called her at 3 in the morning, didn't you?
You know,
Well, I
I
don't remember.
don't recall.
Would
What
it
the
refresh your
time was.
recollection to see a copy of your telephone records? Let's take a look. Here, you read this to yourself. You get the process now?
Mhm.
If it is the telephone records, I don't know.
Oh, that's a problem. Redirect them on it.
That's right, correct. So,
It's a burner phone for the, for the chick on the side.
okay, so I show them the record of
Well, you know the process. You said, I don't remember. Now you say, do you think it would help to refresh your recollection if you took a look at your phone records?
Do you think it would help to refresh your recollection and take a look at the phone records?
I suppose.
So,
Man, work against me.
okay, and so now after you show them, you say, does that help to refresh your recollection?
Does that help refresh your recollection?
It does.
And now you go back to your leading question. You called her at 3 in the morning, didn't you?
You called her at 3 in the morning, didn't you?
I did.
What else do you want to tell in your story about that?
That
You're stalking her, weren't you?
you're stalking her, weren't you?
No, actually, I have a little bit of a problem drinking, which is why I probably drank so much with my wife. And, you know, I was having issues letting go.
So you couldn't let go. You kept calling this lady at 3 in the morning.
I wouldn't say kept, I did it once.
Did it once. I have a record here. You also called her at 2 a.m. 2 days later. This was her. You kept calling her.
Well, as you can see, we actually had a conversation that night.
At 2 in the morning while you were drunk.
Well, at 3 in the morning.
As an
There were several occasions. That's the thing. Yeah. So you weren't entirely over her, were you?
Does anybody entirely ever get over a relationship?
But you were having troubles at home.
Unfortunately, I was, but I was working on that.
I think I see.
You're doing better. That's good.
And don't let him get away with that, right? So you weren't over her, right? Well, is anybody ever really over anybody? Right? So that's a yes, right? Right, so that's a yes. Right, don't let him just.
Yeah, well, and you know, it's the advanced class. So you were working on your marriage by calling this woman at 2 in the morning. I mean, sometimes those things can coalesce and all of a sudden you have something real good.
Yeah.
So your explanation about working on your marriage was to call this other woman at 2 in the morning. Okay, you can see that's sort of an ugly one. But I mean, that's, like I said, that's advanced class. But you did good. You started doing leading questions and that's what we want.
Mr. Ricker, did you choose to work on your marriage or on your affair with your girlfriend?
I chose to work on my marriage.
What's your phone number?
It is 493.
No.
You're gonna let him do it?
I don't know the number by heart.
That's what I know it by heart.
Well, no, he would have to say he doesn't remember.
I don't recall my phone number.
Well, I mean, it's actually a legitimate answer. Look, I don't call myself, and every phone number I have in my phone is somebody's name. I don't remember numbers anymore. We don't do it the same way. I mean, there's a way to.
Okay. Like, I don't know.
look at your own phone and see, I mean, most of the phones are people's names, right?
Yeah.
And I used to know people's number, by heart.
Well, he
I
asked
don't
me
know anybody's
my,
number by heart.
he asked me my number.
I get it.
Oh,
I'm just saying.
What's your phone number?
I don't recall.
Do you recall giving it to the police officer that night?
I must have, because I believe, yeah, I do believe I did.
Would it refresh your recollection if you saw that police report?
It would.
With your permission, Your Honor?
Sure.
Do you
Yes.
recall what your phone number is now?
I do. It is 493-2009.
And you know how people get out of that stuff? They say, look, I just don't call myself, so that's why I don't know my number. I never call myself.
Well, he's my witness. Do you happen to know what phone you were calling from when you supposedly called? No. Do you happen to know what phone you were calling from when you supposedly called the victim?
I don't recall which phone I'd be using. I would assume my house phone that late at night, but
Would it refresh your recollection if you saw the document that you were talking about a minute ago? The reliable wireless phone records?
sure.
With permission, Your Honor?
Please. Just take a look at it, read it to yourself. When you're finished reading it, look up, and then we'll see if.
Take a look at it, read it to yourself. When you've refreshed your recollections, let us know.
It appears it was from a cell phone and not my house phone number.
Let's go back.
I don't know. I don't know how to answer that.
Sam said he did call the.
Okay, just say yes, and I'm gonna sit down.
Okay.
I'm not gonna lead you all the way through this.
Okay.
Because it's actually a bad fact. I'm just gonna say, like, do you see the number?
Yes, I see the number that they subpoenaed.
Thank you.
So why did you go into it?
Because they're different numbers.
Because I'm gonna cross the cop on it. They're different numbers.
Okay, and given his testimony, did you call her?
I said
Yes.
yes.
Okay.
Yes,
Well, why are you gonna make a big deal out, even with the cop?
Right.
All he's gonna do is say, so these numbers don't match, right? But you know that he admitted he called
He
her.
shouldn't have.
I wasn't supposed to admit
He should have been like, oh. I mean, he doesn't say it anywhere. Okay. You're right. You're right. Once the fact's out there, it's irrelevant and only hurts my case.
Well, and the problem is, that makes it relevant.
Yeah.
You repeat it, and then it's like, oh, phones, he's got two phones. Oh, yeah, because he's fooling around on the side. Yeah, I mean, people's mind goes that way, you would expect. Good, Pete.
So,
We have recross, do you need recross, do you want recross?
You?
Do you want me to cross or no? All you really asked me about was the phone records again.
I'm not going again.
I was like, I don't believe it. I don't believe it.
all right, look, I know we're informal in here. Okay, so some of my criticism is about your informality. Oh, okay, right. The very first thing out of your mouth was, I want to take you back 6 months before the incident. I'm a juror, I'm sitting here. What incident? All right, what are we talking about here? Give it some substance to it, right?
We started.
Right? Now, because he's a defendant, right? So we've already heard about the alleged hit and run, right? Let me take you back 6 months before that. Okay, and what did you do for a living? I'm a teacher. I'm a this. I'm a that. Okay, you did it here. I don't know if it's just because we're in class or not. When you said something objectionable, you called yourself on it. Right? Clearly, you don't want to do that in court.
Sure.
Right? If you say something, and I say that because I've seen attorneys do it. Right? They've asked a question and that's objectionable. And even if it is, let the other side object and then move on. Don't get caught up in that. You asked him about the note, right? And he's like, yeah, well, I have the note that I kept. You never marked it or tried to introduce it or.
Oh, I did, right? Because he didn't remember what the note said, and I had to bring it in.
Right, but there's a whole formality to it. You know, you show it to him, do you recognize this? Yeah, what is it? Well, that's a note that I kept. No, tell me about that note. Where'd you find it? I found it in my school box. I found it, right? You're not gonna have this marked as, defendants 1, defendants 2, or what have you, and move that into evidence. You went over it, but the jury's gonna wanna see that note, right? We didn't get to see the note.
Try to publish it.
So,
Because it is pretty bad.
well, you would have in the issue, right? As you're going through it with him, you should have been using those sort of things to bring that out. So, I mean, I would have explored that more, right? And this is where we want you guys practicing the whole techniques, not just questioning, but here's how I'm going to refresh your recollection. Here's how I'm going to object. Here's how I'm going to get exhibits in that I want in. And I'm going to tell you when we get to the final, we're going to expect all of that from you guys, right? We're going to expect you to go through the motions completely. I want this piece of evidence in, lay your foundation, have it marked, get permission from the court to have it admitted, to publish it, what have you. Okay, so we're going to want you guys to do that. Other than that, I mean, I thought good tone, good presence, appropriate questions. You led just enough for foundation and asked to let your guy talk. So I thought overall you did a pretty good job. Victor started out strong. License expired. Yes. Well, and then you didn't lead him on the next question, right? Did you know your license was expired? And he goes on. I work 9 to 5. I got to go to the DMV, and I'm a teacher. You know about teacher schedules, and right? You let him explain that away instead of just your license was expired, and you don't care about breaking the law, do you? You asked it a lot of open-ended questions.
That's why I kept explaining. I was like, maybe if we keep explaining, he'll be like, oh crap, no.
Okay, and then you started crossing, and you got some good leading questions in there. But again, there's a lot to the story, even from the defense perspective that we don't know about, right? We didn't get all the facts out. You didn't bring in any of the facts from your side, right? I mean, you did a little bit about the phone calls and whatnot, but there was a whole lot more to the prior incident. You could have hit him up with, right? You went home right after that, changed into clothes, and you and your wife got your story straight. Isn't it true? Doesn't matter if he says no. You've now planted that seed in the minds of the jury. So have an outline. Here's the issues I want to make sure I'm going over with them and hit them all. Right?
So the planting the seed, even if he answers no, we didn't do that, we'll just it's okay.
And move on.
Okay.
Right now, you don't want to go through the whole story with him and just let him deny everything, but you want to hit the points that just don't make sense, that don't add up. Right? Your license was expired. The whole point you want to make out of that is what? He doesn't care about following the law. So make it and get out short, sweet, right? You could have done a little bit with the accident, right? You didn't want the police involved, right? And you didn't care about, getting the police involved when you were stalking her, calling her at all hours of the day and night, following her when she's out of the club, chasing her down the street, and then just hit him with, it doesn't matter at that point if you say no, because you want to build that story in for yourself. Right, and the jury's listening to your questions much more than they are to his answer.
So even if he objects to all those, then just.
What's the objection?
I mean, when he says no to those.
Right, you're still, at this point, he's already demonstrated he's not the cleanest of guys, right? So make your hay while you can on those points.
So, Vincent, you're the defendant?
Me, yeah.
Okay, so Will, you're doing direct examination.
Correct.
You're the prosecutor.
No.
No.
I'm the
He's the defense attorney.
We went a little out of order. Next, we're gonna do the victim.
Okay, are you the defendant?
Yes.
Right now, yes, I am
The only person who gets to direct examine is the prosecutor if you're the witness. Prosecutors don't cross-examine unless you're being called as a defense witness.
Yes.
Well, that's what
That's
we
exactly what's happening.
I was gonna call
Okay.
the defendant, but
Okay, but
Professor Nolan said I couldn't.
But just follow this now. Okay, so you are the defense lawyer.
Correct.
And you're bringing direct examination on your own witness.
Yes, sir.
Right. So then you are the prosecutor, Victor, right?
Mhm.
So what do you want to do in this instance?
Just reestablish your.
You want to trash it, right?
Yeah.
So that's what you're doing, okay.
Yeah.
So I was very confused for a while. I was like, you're doing direct examination.
Well, at least if we
Call
just.
this guy, what's going on?
Probably
I should've said-
probably better to bring the victim first.
Yeah. But, Will, I think you did great. I think Pete's right. You sounded like a lawyer, you gave the lawyer impression of what you're doing. One of the things you want to get out of your vocabulary is, would it surprise you that Mr. Jones said this or that? That's just the lightweight's version of things,
What should you say?
Well, what, you don't know what time it was? Would it refresh your recollection? See a copy of Officer Smith's police report. You can refresh recollection with anything.
Okay.
So you can show the officer's report to him. You see right here, you want to look at the section here where it says time? Did you see that? Does that help to refresh your recollection? Oh yeah, it's about 10 o'clock. Versus, would it surprise you if Officer Jones said it was 10 o'clock? So you can refresh his recollection. If he says, I don't remember, you can show him anything. You can show him a cookbook. You can show him anything to refresh his recollection if you think it will refresh his recollection. So that's it. It's just, this is, the new lawyers are out there going, would it surprise you about this? And it's like, well, first of all, it's irrelevant if it would surprise him or not. That's not the point. So what you want him to do is say 10 o'clock. So the way you get it is go 10 o'clock, say, you don't remember? Take a look at this report. This is the report of Officer Smith that was taken on that night. Just read it to yourself. That's the way you do it. It's just a simple thing, but I'm telling you, that's the way you get it done. Excellent direct. Of course, Vincent was the excellent chatty witness who said, oh yeah, she had to go for a shrink evaluation for 2 months. And the one thing I would say to you is, you're compromising your own position. You say, it's the same story I gave him at the house or whatever.
Oh.
You don't want to call it a story.
Oh.
I told him exactly what happened. I told him what I told him what happened at the house. I repeated what I had to say. I think we talked about this before. I repeated what I said when they asked me again. It's the same story, but it sounds, as soon as you call your statement
A story.
the same story, it just sounds like, there's something going on there. And then there was this obvious massive amount of hearsay that I was hoping Victor would object to when he says, my wife told me that this, and it's like,
He's calling himself on it.
You have to call him.
you have to say, yeah, you have to say objection. Let's see what else. I think that's all I have here. Just remember, this is the thing, it's so important. It's so hard to be simple, but on direct examination, you want to help your witness tell the story, but he tells the story. On cross-examination, you don't let him say anything except yes or no. And you can do what they call baby step cross-examination, where you start out by saying, isn't it true that you had an affair with the lady? And isn't it true that you had been dating for 3 months? Yes, and you called her a lot. So now I'm not made it a leading question, and you called her a lot. And you called her at 3 a.m. So if somebody says objection, it's not a a question, then you say, oh, isn't it true that? When you do that baby step stuff, you're just telling the story. And you called her, and you called her at 2 a.m, and you called her at 3 a.m, and you went down to find her, and you stood outside her house, and you stood in the bushes, or whatever your story is. So you just tell your story that way. Once you get somebody on the witness stand to say yes, 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 it's sort of close to what Pete was saying. They'll say yes as long as you keep it in a fairly conversational tone, and then they're saying yes, 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 yes. Yes is endorsing your story. So you help them to tell the story, you tell him the story and get him to endorse it on direct or cross. If you can remember that, it makes it so much simpler, because then you don't have to have a big long memory. What's the story? I mean, what's the beginning, the middle, and the end? Start at the beginning. Just start telling the story. You know, going back 6 months is fine as long as we know why you're going back 6 months. You're charged with having an accident that you didn't report with Miss Smith, yeah?
Well,
Isn't that what happened?
Yeah. Oh.
Whatever it was,
Yeah.
it was a side swipe or whatever with her, right? And so you say, well, let's go back a little way with your situation, your relationship with Miss Smith. So now you know you started with an accident, and now you're going with Miss Smith. Now you go, let's go back and talk about your relationship with Miss Smith starting maybe 6 months ago, or go back 6 months ago, and what was going on and what happened and that kind of stuff. So the direct example, and of course he can be sympathetic about that too. You know, I really was working a lot of hours. My wife was not home all the time. I started getting lonely, you know, you can say all this business, and then I realized how wrong it was, but I couldn't quite figure out how to stop it. And, you know, you can do all that to try and get sympathy. That better not have a lot of women on your jury if you're going to get sympathy in that one. But
So, say, I guess my question is, say you have a witness like me, where you ask them leading questions, and they say, yes, but, and how do you stop that?
well, you ask them the same question again.
Okay.
Isn't it true, Mr. Jones, that's your telephone number? Well, it's my telephone number, but it really, well, I don't know if it's about your number. Okay. Isn't it true, Mr. Jones, this is your telephone number? And so once you've heard all the nonsense and the explanation, then you say, and it is true, is it not, that this is your telephone number? So you keep going back to the question until you get a yes or a no.
Yeah, I kind of did that just like in
Yeah, I know. And you're messing around with it. And witnesses do this all the time. God, cop witnesses just love to try and give you a diatribe. Oh, you know, what happened. You don't ever say what happened to a police officer. You say, didn't you arrive on the scene at 12:45? Yeah, I got there and I saw this guy with a knife trying to stab his wife. Okay, but I'm just asking you got there at 6:40, right, sir? Yeah, and so that happens a lot. So at least that's one technique. It's not the only technique, but that's one technique. Repeat the question again after they've done it.
Okay.
And then if they keep doing it, you can say, because you want to be in charge, 3 or 4 times, you can say, Your Honor, could we get the court to order the witness to answer the question as asked it?
Mm-hmm.
You don't want to act like, gee, Daddy, come and help me.
Yeah.
So you wait till you've had that experience several times and you've re-asked the question. And then you might ask the court, would you please order the witness to answer the questions that are asked, or whatever. But yeah, believe me, they're all over the place in court. Witnesses want to tell you more than you're asking for.
That's why I kind of did that, just so I could be like, how do I take control of that?
That's just happening. That's it. That's what's happening.
Well, and witnesses do. You know, witnesses absolutely try to take control. And you gotta be confident enough in your abilities to counter that. So, all right.
Ready, Miss Evans?
So now,
He's guilty.
Victor.
She's the victim, or he's the victim.
Gender neutral victim.
Yeah.
And Will is the,
Still defense.
well, you're the.
And the prosecutor.
So you're
Crossing.
You're on leading, you're on cross, and you're on direct. Okay.
What's that now?
Your Honor, may I call Miss Donna Kevins to the stands?
You may.
Good afternoon. Can you please state your name for the record?
Donna Kevins.
And Miss Kevins, do you remember where you were on October 5th of last year?
I was driving home.
And Did anything out of the ordinary happen when you were driving home?
Yeah, I got driven off the road.
And do you know who drove you off the road?
It was a Mr. Griffin.
And how did you know that it was Mr. Griffin?
I saw him.
How did you recognize Mr. Griffin? Had you seen him before?
Yeah, I worked with him at the school.
And when you looked over, was Mr. Griffin doing anything that caught your attention?
Yeah, it looked like he was trying to roll the window down, but he wasn't able to. He was struggling.
So he wasn't able to open up his window?
Yeah, he was trying to roll it down, and then he drove off and he flipped me in the finger.
Did when he drove by you and flipped you off, what had happened right before that, if anything?
He hit me with his car.
So instead of driving off, instead of pulling over, he flipped you the bird and drove off?
Yeah.
And did you happen to call 911?
I was a little fuzzy, so I called him when I got home.
And would it help to refresh your recollection if I don't know what to show her.
What are you trying to say?
That she called 911 before she went home, but it's not in her statement, it's in the police report. It's in the police interview.
Recollection to see the police report about what time you called.
Well, it's the police interview.
Well, you can.
Can I show the investigation
You can
narrative?
show anything you want that would refresh their recollection.
Oh, okay. Would it help to refresh your recollection if I showed you the police report showing that you may have called 911 before?
What do you think? We'll say, or shoot, I don't know.
Overruled.
Hearsay?
You can refresh
Hearsay.
your recollection. Take a look at it.
Okay, hearsay.
Overruled, sorry. Read it to yourself. When you're
Read it
finished
to yourself and then let me know
Is that
when you're done.
No,
He's allowed to say that says blah, 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 blah.
he's not allowed to say that unless he says, I don't remember it, I don't recall, even after seeing it. Then he can do something.
Okay.
But of course, you normally don't do that to your own witness.
You did that afterwards. So, do you remember when you first called 911?
9 o'clock.
And was that right after the accident?
Yes.
And when you called the police, the first time, did you let them know who had hit you?
No, I was still fuzzy.
And so what happened after you had collected yourself at the scene?
I went home and I called the police again
And why did you call the police again?
because I knew who it was. It was Mr. Griffin.
And why didn't you tell them that when you had called the first time?
I was still in shock.
And so after you called the police, what did you do after that?
Well, I wanted to make sure they got the guy, so I drove to his place.
And when you got there, how were you feeling?
I was angry because of what he did.
And so were you in control of yourself when you got there?
No, I wasn't.
And so what did you do when you got to this house?
Well, I don't like the smug look on his face, so I lunged out.
And so were you ultimately put in handcuffs?
I was.
Were you ever arrested or charged for that?
I wasn't.
And so you were able to hear the story that he gave the police officer?
I don't remember.
Okay. So you said that you worked with Mr. Griffin, correct?
I did.
Did you know him in any other capacity other than that?
We kind of dated
And about how long did you date for?
6 weeks, about 6 months,
And did it ever end?
about 6 weeks ago.
And did he end it?
No, I ended it.
And how did he take it?
He didn't take it very well.
Did he do anything that caused you concern?
He kept calling me at all hours of the night.
And Your Honor, or actually, one second. Do I show them?
What do you want to say?
I want to bring in the phone record, but do I show it to them first to?
No.
I asked the judge first. Okay.
No. What phone record are you trying to get in? His phone.
His phone records between the two of them.
Okay. So, did he call you? I mean, what?
Well, she just said that he called her incessant or at all hours of the night.
Right. So, do you really need to then refresh anything?
Well, I don't want to refresh it. I want to enter it in as an exhibit to show that he's calling her at all hours of the night.
Okay. So now you're authenticating. You're not refreshing recollection. So, I'd like to place what I've marked as
Exhibit A or Exhibit
A before you. Do you recognize the telephone number on Exhibit A?
Okay. I'd like to introduce.
No, you don't introduce it.
Wait.
You gotta get it authenticated first. I would like to place before the witness.
I'd like to place before you what I've marked as Exhibit A. Do you recognize the phone numbers that are on there?
Yes, that's my number, and that's.
Okay, so just stop for a second. So, would you take this pen and circle the number and write whatever her name was? What was her name again?
Donna Evans.
DK next to that number. So now this witness actually identified her number, and she's identified which one is her number, because he's pointing his finger on a number. That doesn't help the jury or the judge or anybody.
Well, it says Donna Kevin's cell phone number right next to it. Okay.
Take it, circle around it.
Okay. So can you go ahead with a pen and mark which phone number is yours? And then next to the other phone number there, can you tell us who was on the other line?
The other number, that's what shows up on the caller ID when Mr. Griffin calls.
Your Honor, I'd like to enter into evidence Exhibit A, the reliable wireless cell phone record.
And just for process purposes, you're just one step ahead of yourself.
Oh, okay.
I'd like to publish this to the jury now. You're on the Elmo. I'm going to put this.
Oh, okay.
Now, you just have to, now you have to repeat it. So, Miss Kevin, you put your initial DK right here by this number, 877-555. That's your number, right? And then you've written the initials of Mr. whatever his name is right here, right? And so now you've actually had him identify it on the witness stand, and now you put it on the Elmo to make sure that you publish it to the jury. So now you've said it twice, and now you say, would offer people's exhibit number 1 into evidence. It's just a step-by-step process.
Yeah. So I'd like to publish to the jury Exhibit A, the reliable cell phone records.
Any objection? Hearing no objection, yes, you may.
So, Ms. Kevins, as you indicated, the 5561632 number is yours? Or no, the 3925039 number is yours? Yes. And the 5561632 number you said was the number that came up when Mr. Griffiths called you?
Yes.
So, can you explain to the jury, perhaps seeing as you had ended the relationship, why there was a 39-minute phone call?
He sounded drunk, he just kept going.
And did you feel sorry for him?
A little bit, yes.
And so, I guess I have no further questions for this witness. Because I'm not bringing any more issues to school.
No.
Can I bring that for you?
Can I have Ross for?
Yeah.
Okay. Ms. Kevins, thanks for being here. I want to start about 6 months before the incident when you started dating the witness. Is that true?
That's true.
And how long were you dating?
Up until 6 weeks ago.
So that's 6 months. You were dating for 6 months. And about 2 months into this, you had some kind of breakdown?
Leading question.
Okay.
So you tell her, what you want her to say yes to. You tell her. Just start at the beginning again with what the first question you asked.
Isn't it true that you were dating, that 6 months ago you began dating Mr. Griffin?
Yes.
Why would you date him now?
No. And isn't it true you knew he was a married man?
And isn't it true you knew he was a married man?
Yes.
And there's a variation. You knew he was a married man, didn't you? Right? Because that makes it a question as well. So you can do, isn't it true? And then you can assert what you want to hear and say, isn't that correct? Isn't that right? Isn't that true? So that every time that you ask a question, you're telling your story. So try and do it that way. Just it takes practice, but
You knew he was a married man, didn't you?
Yes.
I want to move forward a couple of months. You had some kind of incident at school, right?
Objection relevance.
overruled.
I did.
Is it true that you had a breakdown?
There's
What is it? As part of this breakdown, you were placed on leave. Isn't that true?
yes.
And they had a psychological evaluation done?
Yes.
Do you recall a Dr. Garrett Strong?
Yeah.
Is he the person that performed the psychological evaluation?
It was.
Do you recall him saying, I want to pose at this point,
What do you want to get out?
that she's had exhibited classic signs of histrionic personality
So once I
disorder?
get the psychiatric report in,
Right.
I'm gonna object.
But
Well, I'm making it in under the federal rules.
yeah, you might. But remember again.
I guess the.
Didn't Dr. Crum diagnose you with a psychiatric evaluate or with a psychiatric problem?
Objection relevance.
Goes to bias. I mean, you could come up with some reason why it's relevant. Remember, we get almost anything to be relevant if you can put together some argument for it, right?
Mhm.
Goes to bias, might go to competence. Right?
Yeah, okay.
But again, if you want to get in some statement with the doctor, say, isn't it true that Dr. Crum told you you had some sort of psychiatric issue or whatever, versus trying to say, well, you tell the story. Don't let him have any control. Her.
Is it true that he said that you have some psychiatric issues,
Yes.
including excessive emotionality?
Objection hearsay.
How do I get this in? I don't know how to get it in. The problem is I'm trying to cross, and if I were just to direct, is it okay to step into like a normal direct and say like, do you recall seeing this doctor? Like,
Well, but
Or is this
why do you
report that-
want to do that? Don't you want to just get what you want in? So making it direct instead of cross doesn't make it any easier to get it in. But I mean, you can do whatever you want, but the whole idea in cross-examination is to get it in.
okay.
So what you got to think about is, what's your exception to the hearsay rule? Not offered for the proof of the truth of the matter stated would be one, right?
It's a statement made for medical purposes. It's an explicit exception under the federal rules.
Good.
Wait, what's your exception that you're using?
Statement made for medical diagnosis. 8034.
But you're not using her statements against her, you're using the doctor's diagnosis, which is not a statement made for medical purposes.
It's not.
His statement is made for medical
It's a statement
purposes.
made for medical diagnosis. This is a
So it's a doctor's statement made for medical purposes, and the purpose of the admission is to show bias or whatever.
I don't even need that. I need it to show past or present medical symptoms, their inception or their general cause. That's all that I need under the federal rules, and I'll get it in.
Okay. You may who's your judge? Yeah, but you know what? Judge judges don't always do.
Yeah,
It's also,
this is
it's a psychiatric
this is
note.
this is clearly something you're gonna have, discuss pre-trial.
Right.
yeah.
You're not gonna have it now.
Just go, because
there's-
it'll mess with your cross, I mean, it's.
Okay, let me just not worry about it. I'll just, isn't it true that you have excessive emotionality?
That's what they tell me.
Isn't it true that you have attention-seeking behaviors?
That's what people say.
Didn't you tell this doctor that you have difficulty gauging the appropriate level of intimacy in your relationships?
That's what he told me.
And isn't it also true that you admitted having fantasies and having fantasies about the behaviors and emotions of others?
I don't recall.
Would it refresh your would it refresh your recollection to see the doctor's report?
Sure.
With your permission, Your Honor?
Sure.
So let's read this to yourself. This paragraph right here. Let me know when you're finished. So does that refresh your recollection?
Yeah.
So now ask the question again. If you remember.
Do you project your own fantasies onto the behaviors and motivations of others?
So just stop right there. Can you see what's the problem with that? No, I don't. I don't know why anybody would say that. That's ridiculous. Instead of, isn't it true that you project your fantasies on others? You get the leading question versus the open-ended question?
Sure. Isn't it true that you told this doctor that you project your own fantasies onto the behaviors and motivations of others?
Yeah, so we only talked about it for a little bit.
Okay. I want to move forward to the date of this incident. Can't refer. Okay. Did you speak the day before with Mr. Grifford?
I don't recall.
Would it refresh your recollection if I showed you what's the thing called? A record of phone calls made?
Yes.
With your permission?
Sure.
Just check out these dates. Remember this happened on the 5th of October. So did you talk to Mr. Grifford on the 4th?
Yeah, I talked to him at 2 in the morning.
Did you talk to him? So, yeah, 2 in the morning on the 4th. Is that before or after?
It's before, because it happened on 10/5.
No, but my accident, did she know?
No, that's before your accident.
Yeah.
Unless they hit the guy at the school at midnight.
Yeah. I don't know where I'm going with this. Then.
But I didn't want to give you satisfaction.
Did you work with Mr. Grifford? Or you work with Mr. Grifford, correct?
Yes.
You're math teachers together, correct?
Yes.
You work closely with Mr. Grifford?
Yep.
So you're both math teachers at the school?
Yes.
Same department?
Yes.
You have constant contact. How did it feel when he broke up with you? I can't say that. It's open.
What do you want?
It hurt your feelings when you guys broke up, right?
Yes.
You were devastated when he cut off the relationship with you,
I
weren't you?
was like, I don't want to contradict myself.
Right. Well, I want to load it in a way that you are contradicting yourself, but it's a yes or no answer to how you feel, not about whether or not who broke it up.
Good.
So you were devastated when Mr. Griffin ended this relationship, or you were devastated when this relationship ended, correct?
Yeah.
Where were you on Saturday before the incident occurred?
I don't recall.
Isn't it true that you were at a bar?
Yes.
Isn't it true just now on crossing on direct, you said that you were fuzzy on the ride home?
I had just been hit with the car.
Why didn't you tell, but you didn't tell the police who hit you?
No.
Instead, you went home and waited over an hour before calling the police again. Isn't that true?
Yes.
Or isn't it true that you waited over an hour before calling the police again?
Yes, I was still shocked.
When you called the police again, this time you were mad, correct?
I had,
Were you mad when you called the police at 9:50?
yes.
Well, and then you decided to drive over to Mr. Griffith's home.
Yes.
You knew where he lived.
Yeah, of course I lived.
Why did? And then when you arrived there, you hit him.
I was mad. I want to make sure he got what he deserved for hitting me at the start.
So is it true that you think he deserves to be hit?
I was angry.
Did the officer restrain you at that time?
Yes,
He put you in the back of his police car, didn't he?
he did.
And then he arrested Mr. Grifford and let you go?
Yes.
No further questions.
Good. Definitely started using more leading questions. It takes a while to practice it because you definitely need to eventually get the discipline that you are very rarely going to ask anything but a leading question and cross-examine. It takes a while to get used to it.
Talking.
It is. But remember that you want to keep control over this witness and you want to tell your story out of your mouth and have them endorse it. And that's the other thing. If you said, this is the old technique Jerry Spence used to say, once upon a time, what is her name? Jean?
Donna Kevin.
Once upon a time, Donna went and sat in a bar and got drunk and got sideswiped and got home and decided, this is my way to fix this guy's wagon. I'll just call and blame it on him. So you just have this little story that you come up with like that, and then you just ask questions that move that story forward. And then the problem is if you don't have your story clear in your mind, you can't move it forward. So you got to get your story clear in your mind. And on direct examination, it's just the opposite, as I mentioned. I'm repeating myself, but you get him to tell the story, but you lead him. You don't lead him. You direct him through the story. What happened next, and how did you feel about that? But you let him talk, and you want him to talk because that's the person that you want the jury to believe. When you're doing cross-examination, you don't want them to believe him. You want them to believe you. Mm-hmm. So that's the little trick that eventually takes a long time to get used to this kind of stuff. It really does. But you started doing that, which is fantastic.
You're trying to trip me up on loaded questions, right?
Well, yeah, I want you to answer a question while stating my facts.
Exactly.
I mean, that's the goal, right?
Right. You state your facts and get them to endorse it. So you got to be careful because if you overstate your facts, then you get this person that wants to, give an explanation. You make your facts very short and sweet and go step by step. It's hard for them to give an explanation. And I thought you did fine. I don't know if you want to do any more redirect. I don't think you need to do any more. But
I was going to ask her about this damn note, but it's all right.
Oh, that's a good point. Good point. Way to get the note out there. Victor was a good witness. It was hard for me to visualize you as a woman, but I was trying.
That's good.
I think all of you are picking it up. I mean, believe me, this is advanced compared to what people get in law school usually. Then you might have a trial practice class, but even that's a little iffy. And then you see people that are taking their first 5 years to figure out how to have a trial. I want you guys to be a little bit ahead of the game, so that's why we're being emphatic, Vincent. That's why I'm being emphatic.
And you got to keep in mind, now clearly when he's going through that site report, you're going to know before that ever starts if it's coming in or not.
Well, that's what we had the discussion too. Clearly, this would be a motion to eliminate issue, and
right.
We would know beforehand.
Yeah. But
I think it's a refresh your recollection about her own issues, right?
Yeah, but you don't do it through the report, right? You ask her. So you're aware that you have mental issues, right? You've been diagnosed with A, B, C, and D, right?
She's not
Do you take any med? Well, but what if she says yes?
dumb, right?
What if she says yes?
She just played clocks.
Right, and you have problems, with the appropriate levels of intimacy in your relationships, don't you? I don't remember. Oh, would it refresh your recollections if I showed you this report? Right, you're not going to say the psychiatrist report. You're going to show Cal, so I'm going to show him right here. It says refresh recollection. Yeah, so you said that. I think it's a stretch to think that's going to come in under, for medical diagnosis, right? It is privilege, and it is hearsay, and it is irrelevant, but irrelevant is such a weak argument, so what's the one that goes along with that?
It's irrelevant and more prejudicial than
Absolutely. It's totally prejudicial, right? This is so prejudicial against her case, you know.
But I think if you had that information, there's another thing that's, again, this is the advanced version, but I want you to get this. Jerry Spence does a lot, called compassionate cross-examination. So you say, this has been really tough on you, hasn't it? What's her last name again?
Kevin's.
Miss Kevin's. It's really been tough on you, hasn't it?
Yes.
And it's really taken a toll on you, hasn't it?
Yes.
And you've developed issues as far as intimacy, haven't you?
I have.
Yeah, and so can you see how if you're nice, sometimes you can get them to say the stuff that you can then use in your closing argument? So that for women, for children, very common technique for the real good lawyers to just really be nice and pleasant and sympathize. And you want to feel like we're sympathizing together, but then you want to ask, what were the other things that were wrong with her?
Yeah, she projects her own fantasies onto the behaviors and motivations of
Yeah,
others.
and so you've had problems, you know, with intimacy, and you've actually projected fantasies, your own fantasy on other people, haven't you? Yeah, and so, you know, you can actually get them to say things that are devastating in your argument, but you get them out because you're the opposite of what the TV lawyer is all the time, which is, isn't it true that you have fantasy problems, whatever? So just remember, sometimes you have to look at the witness, especially if it's a sympathetic witness. If it's a kid or a woman who's crying up there, the last thing you want to do is start screaming at them. So you got to think about that too. And remember, with your leading questions, if you do it right and you get them to roll and they start saying yes, you can start bringing up the stuff that's a little difficult to deal with, and they're still saying yes, and they're still saying yes. And you know, as an example, sometimes they would use this on snitches if they were sympathetic snitches, and they'd say, well, you know, it's certainly understandable. You have children, you have a family, and you don't want to be sitting in this prison any longer than they have to, do you? You know, so you actually give a reason why they would be doing what they're doing, or saying what they're saying, or lying about what they're lying about. So it's just something else to think about. There's a lot of things, there's a lot of ways you can handle witnesses. Right now, we're just trying to give you the real basics. What if anything happened? Isn't it true that is really direct and cross?
Can you object to recollection refreshing documents, though, since the jury doesn't technically see them?
Well, no, you can't. I mean, unless it's ridiculous, but I've had judges say on any number of occasions, you can refresh recollection with anything. So
technically I wouldn't even be able to really object to this until he tried to show it to the jury?
Well, it's not.
Or he's asking about it.
It might not be admissible, but it might help to refresh recollection. So that's why, you know, just because you refresh recollection doesn't mean the jury gets to see that.
Mm-hmm.
It just means that person now can answer the question.
But so how does somebody object to that like line of questioning? Like if he starts going down, you have issues with intimacy, right? I know where he got it from.
Right. Well,
and if she says no, then you can impeach her anyways.
It's back to your thing. It's the 402 thing. A judge is going to say you're not going into that. That's a private psychiatric evaluation. You're not going into that. Do not go into that. Do not ask questions about that. And so usually that problem is solved.
Okay.
If that problem is not solved and you know it, ask it in a leading question, what manner? And then if there's an objection, well, you know, the problem with objecting to things like that is it draws attention to it. And so even though you could object sometimes, you don't, you know, you have to use a judgment call again. But yeah, so that's the answer. I mean, you had the right answer at the beginning. You got to deal with this in the motions to eliminate.
Okay.
And you're not going to have psychological evaluations come into evidence.
Well, I mean, this is kind of a PR question, actually. I have this, I don't know that they do, and it's impeachment.
Well,
because the wife stole it.
Yeah.
Well, so you've got foundation problems then too, don't you?
Well, yes.
How do you prove that's a psychiatric evaluation about this person?
I have to
By
do it
calling your
across.
wife in and saying, I stole it?
No,
That
I
ain't
just
gonna work.
do it through her.
You can't surprise you can't surprise people with evidence.
Okay.
You have to, if you're going to use something and you know you're going to use it, you have to give it to them.
But I don't know that I'm going to use it. I mean, this is probably what
before you use it,
Yeah.
if you decide in the middle of trial you're going to use it, You need to bring it up outside the presence of the jury. There's no more ambush trials. You can't do it anymore. So, I mean, I get the part about, you get an edge and, whatever. Well, unfortunately, that competitive part of trial activity is gone now.
Theory.
Yeah, and it's been my experiences that courts are not fond of that argument.
Yeah.
It's very common. Is all footnote number 7? So, right? They say, I don't have to turn over impeachment evidence, right? That's what this is how it says. Well, they do. If you know you're going to use it, you have to turn it over. I don't know I'm going to use it.
Right.
Really? You didn't know you were going to use that till right now you're questioning it, right? Courts are not fond of that argument. I've seen
that could actually cause a mistrial.
Yeah, I've seen plenty of defense attorneys get slapped around when they try to pull that and they think I didn't know. In fact, I had one where the attorney judge was laying into him so bad. He was a public defender that the public defender brought over like a senior attorney, a supervisor, and to come over and say, well, we had talked about that, and our discussions, we hadn't concluded whether it should or it shouldn't come in.
Throw him under the bus.
Is that just a criminal thing? Because I know like in civil, we do it, or I've seen firms do it a lot more. Like, it's a surprise.
But it's not a surprise in trial. It's a surprise like in late discovery, like not late discovery, but like you don't just hand it over. You like, I don't know. Have you seen a trial?
Bury it in discovery.
You've seen a trial already?
Oh, I haven't seen the trial, but I hear about every day of the trial. But yeah,
People do that, but really, if you're going to be a professional, anything you're going to use, you give to the other people. And if you think, I don't know if I'm going to use it, when you finally decide you are going to use it, you say, I want to have a hearing if I can. Look, we think now that we should bring this in. I want to show it to you. I want to show it to the court. You always conduct yourself that way. There's no secret evidence that you spring on somebody in the middle of trial. That's just bad TV. It really is. And by the way, it really is a much better practice because then it doesn't happen to you as well.
yeah,
Right.
And you do have if you get known for that, by the way,
Right.
you're in trouble.
Yeah.
And if somebody does that to you, and you've got the right judge, I mean, that's probably a mistrial if you want one. Sometimes you don't want one because you've been so far down the road. But a judge can also do what they call a curative instruction, and you say, Mr. Jones had mentioned this. That also brings attention to it, which is a problem. But no, there's in the real
No more
world,
secret evidence.
we don't have ambushes anymore.
Okay.
Although it sounds fun to be able to, woo, look at this, we got you. But in the real world, it doesn't happen.
Yeah, and it's funny, it's sometimes it's little technical stuff. I remember I had one where they sprung something like that. And it was a defense investigator's report. And in this defense investigator's report, there were all these inconsistent statements. Really, when I call this victim to the stand, you're not going to hit him with these inconsistencies? So, defense attorney tried to say he didn't know he was going to use it. But then when he did try to use it, I objected and said I hadn't received a copy of it, and I want a copy of it. And a judge in front of the jury and everything ordered the defense attorney to provide me a copy. We came back the next day, and the judge corrected him. So this was a judge that was really good on the law. And he was caught off guard on this one. He said, you know what? I made a mistake. Counsel did not have to turn over a copy of the report at that time. However, he should have advised and what the statements were, because there was other stuff in the report besides those inconsistent statements. So he didn't have to turn over the whole report, because it turns out that there was more in the report that actually helped me besides those inconsistent statements. And he was under no obligation to turn the report over.
Well, it's your attorney by product. It's your investigator.
Yeah.
It's actually privileged, I think.
Yeah. So it was a situation where you knew you were going to use it. And if you knew you were, you had to turn over those statements. You didn't necessarily have to turn over the whole report. And, that's rare too, that a judge sit on the bench and tell the jury, hey, I missed this one. You know, let's fix it. And ordered me in front of the jury, you need to return all copies to the defense attorney. Okay. But of course, at that point, I had seen everything too. So I knew the information that helped me. So.
I think everybody's making progress. This is a hard thing to do, to be natural and converse just like you would be if you were just talking to somebody. But you're making progress, and that's what counts. And just remember, on direct examination, what, if anything, did you do? What's the next thing you do? All open-ended questions. Cross-examination, isn't it true that? If you can just try and push yourself to keep that discipline, it'll make a big difference. It really will.
All right. Next week, we start closing out.
We do closings?
No, yeah, well, next week we do lecture.
Oh, lecture, okay.
Lecture on closing.
Well,
And that's
we'll give our theories on closing, but I've already told you part of it. My view is it's always one question short of the last question. Save it for the argument. You know, because then they can't respond back. That means the witness. Obviously, the other side responds to what you say, or they should anyway. Yeah, and that's the fun part, the closing argument. Everything is leading toward that. All right, so we'll have lecture next week.
Lecture next week.
I will be not here next week. Is that true? Yeah, I leave on Wednesday. My sister-in-law is turning 70, and so we are going to Guadalajara and to the city of tequila. Apparently, there's a city. She's a big tequila fan. And I really didn't want to go, but thank God, after all of this stuff and the stuff I'm finally finishing up, I'm very happy to get a break. So we'll be gone from, I think I might miss 2 weeks now that I think about it. I'm embarrassed to say. We leave on Wednesday morning and we get back, I think we get back the following Tuesday. Yes, I could be here Wednesday. So 1 week. I'm missing Pete's lectures, so you're going to have to listen carefully.
It's going to be brilliant.
I believe it.
Absolutely brilliant.
I'm going to sit for it though.
No standing. All right. Well, I'm going to go and pass out. But it's been a good couple of weeks, but very good. So Pete, did you say you got to go to the Eagles, or you just were learning?
Yeah. No, they were
Thanks, sis.
I didn't think there was.
I didn't pick up on any of it.
I just. And I'll see you on Saturday. Don't forget that Wilson Trust Fund.
Oh, yeah.